Welcome to Criminal Law Unfiltered.
Welcome back to Criminal Law Unfiltered with Robert M. Helfend. Robert is the founder of the Helfend Law Group and a criminal defense attorney who focuses on serious state and federal cases. With more than 4 decades of experience handling felony matters across California, he's seen how the first time someone steps into a courtroom often sets the tone for everything that follows. I'm Evan Mack, and today we're walking through what actually happens at the first court appearance in a felony case. Robert, my man, welcome back.
Thank you. Nice to be here.
So, Robert, what is the purpose of that first court appearance in a felony case? What's actually being addressed at that stage?
Well, actually, it depends on the charge. But the first court appearance, the most important thing is, if it's a felony, is your bail. Many times people are arrested, they post bond, and then you go to court. But if you haven't posted bond, it's, some way, somehow they've, the DA's office hadn't, or even the U.S. Attorney's Office hasn't filed the case on time, you get a letter saying, hey, come on in. So it's really important for your counsel to contact the DA's office and talk about bail before you walk in there. And if that's not possible, nobody will address it, then you need to tell your client, listen, there are issues here because the judge could set a bail on you. You either haven't posted a bail because they didn't file it on time, so your bond was exonerated, or you've actually, and many times you have posted a bond, and then the charges that the DA files are a little more serious. So you need to have your client aware of those possibilities. I've seen it many times, especially in one courtroom in Los Angeles County, where the bail issue comes up and the defense attorneys doesn't look too good in front of their client because the client's going, well, why didn't you tell me this? So the way to prepare for that is, you have your client contact his bail bondsman, and you have them actually in the courtroom with you, just in case. And so that if they do raise the bond or if they do set a bail, you have your bondsman there and you just request the court to allow them to sit in the courtroom while we post the bond. So that's the most important thing that you need to be aware of on the first court date.
So, Robert, what information is being presented to the judge at that point? How much of the case is already in play?
Probably none of it. You can't get discovery before you make your first court appearance. Every police report, a police report is basically privileged information. So they can't, or the police or the DA's office cannot reveal that information to just anyone. Okay, then the police report would be in every newspaper around if a reporter wanted it. And so they can't get that stuff. So you don't have any of the information. Now, in Los Angeles County, when you go to the first court appearance, they will give you they'll hand it to you. They'll hand you the initial report so you could actually go through some of it with your client. Obviously, it's a lot of information and you're not going to be able to go through all of it with them, but you could go through some of it, which is helpful, especially if the DA is asking for bail or a raise in the bail. At least you could see, well, this is what it says, Judge, and we need a opportunity to defend against this.
So how early do decisions made at the first appearance begin to shape the direction of the case?
It's not really, it's too early in the game, especially my cases. My cases drag on for a while. The first court appearance is just, hey, it's like a track meet. Ready, set, go. The gun goes off. Am I thinking about, that's not a good analogy because if you're in a race, you're in a running race, you probably have a strategy. But you don't really have a strategy yet. You got to see because this is all about fighting or rebutting what the DA has, not you have an idea of what what's going to happen here, but you need to go through what is the evidence in the case. Okay, because this is not, I've said this in other episodes, and it's very important for people to understand this whole legal process is not about the truth. No matter what the DA says, it's not really about the truth. It's about evidence. I mean, I can say, hey, this should be in a jury trial. I could say, hey, this is supposed to be truth finding. Okay. And, but I mean, the police are never interested in seeking the truth. They're just trying to win this case. I mean, it doesn't matter. Even in this case that I'm in right now, if you really go through the weeds and see what happened here, you should just you should anyway, you should back away and yeah, you're right. But it so you don't really know until you go through the evidence with your client, and they need to see, the evidence, the pictures. They need to read the discovery themselves so that they know what they're facing. And also, when they get a copy of the reports and the evidence, they actually will give you the best defense. I mean, what is it? What really happened here? And so that's how you do things.
Yeah, yeah. So, but what about the bail? How do bail and custody issues usually come into play during that first appearance? Is that when you kind of present the bail or things like that?
Well, we talked about that already. You have an idea. Well, on a homicide, bail in Los Angeles County is $2 million. So if your client is, um, if you're defending somebody on a murder case, they're already in custody normally. And then they come for the first appearance, bail is $2 million. Last year, uh, I have that case next week. I had a murder case where I got his bail reduced to $1 million and he was able to bail out. So he's out while we fight this case. Um, you kind of know what the bail is going to be. Normally, people are out on bail. The I don't know whether or not they're going to, and when you bail out, by the way, you already know the charges because you get a bond out slip from the bail company and they show you what the charges are. So when you walk into court and then you get their initial discovery and then you look down at the complaint, it seems that the charges are worse, then you better go talk to the DA about bail. Also, on the third or fourth page of the complaint that they give you, there's a recommended bail. So you'll go, oh, wow, my client is posted 500,000. Your recommended bail is 2 million. You need to have a little chat with the DA. Are you asking for this? Are we going to argue this?
So what does anything go wrong or typically go wrong for defendants at this stage that can kind of create problems later, or is it pretty straightforward?
Nothing can go wrong unless unless the client realizes their bail's going up and they run. I mean, even that, that's not gonna make it that's not gonna do anything really to the case. Um, it's just gonna make it more difficult for you because if they run, and they get away, when they come back, their bail's gonna be higher, then maybe the client can't afford that new bail. Who knows? I don't know. But no, there's nothing really. Um, a first court appearance is really kind of blah.
Mm. Not like the TV shows make it.
Well, I haven't seen a TV show that, I haven't seen a TV show in their first court appearance. I don't really know what, what people expect.
They do make it very dramatic on TV, they do, like, they
Not dramatic. I mean, it's really even a jury trial is not dramatic. And I always talk about that. A lot of times, the prosecution will talk about that. What are you expecting? Are you don't expect in my day, the legal show of, the day was called Perry Mason,
Great show.
and on Perry Mason, they'd have somebody on the witness stand, and then Perry would say something to them, and he's cross-examining them, and then the witness would all of a sudden break down, "Okay, I did it, I did it." It's not like
The
that.
great Raymond Burr.
Right. Okay, Raymond Burr, right, exactly, and so it's not like that, and you don't expect people to and you have to tell juries this. Look, it's nobody's coming in here and, as Perry Mason, nobody's gonna raise their hand in the audience and say, "Okay, I did it," or somebody that's on the stand. I mean, even when you even when you, catch a witness in a lie, they're not like, "Okay, I lied." They're
Mhm.
they're gonna try and, explain why they said what they said or deny it, and then it's up to the jury to decide who's lying and who's not.
Mm,
It's not like that, but I think it's interesting. I mean, this case that I have now is very interesting. I have put on a mental health professional, and so the jury's gonna have to weigh the, um the evidence about what my doctor said that, my client is schizophrenic.
mhm.
Schizophrenic, or he's got schizophrenic symptoms,
Ooh,
and, how that affects somebody when they're about to pull the trigger.
right.
So,
So, do you have an example at all, in all your years of experience where something happened at that first court appearance that had maybe having a bigger impact than you expected?
let me think. I'm thinking, no. No, I mean, no. I don't have any real, and I've done this now a long time, 43 years, people, and I don't have experience about and where somebody did something at the first court appearance where it affected the entire case. Like I say, the first court appearance is really it's just all about bail. It's about nothing other than bail, and then, when you're gonna come back. That's it. So it's real I can't think of anything.
To kind of wrap things up, though, what do people often misunderstand about that first appearance that can affect how they approach it? Are they overthinking it? You just said it is just about bail, but is there any other misunderstandings they may have?
It's not well, people who've never been in the system, never had a case before, they're nervous, I understand that, and you really need to kinda step back and go, "This person has never, been to court," so you kinda have to let them know, "This is what to expect. Don't be
Mm,
nervous. There is a bail issue." The I've had many times where I've told somebody, "There's a bail issue here you gotta be aware of, and so maybe we should have the bondsman come to court with us to take care of this just in case," and they don't bring the bondsman, and but things turn out okay. Many times, that has happened where I'll tell the client about, "There's an issue with bail because you have a prior conviction. That prior conviction is worth another $50,000 in your bail. They may or may not ask for it, increase in your bail of 50,000. So we got to be aware of that. And then they're ready for it, and when we get there, uh, they don't ask for it. They leave the bail where it is. So, just gotta make sure it's all about the client and whether or not the client is comfortable. And I just like to let them know of all the different things that could happen on a first court appearance. And the first court appearance is just really about the bail. I know we've now spent, 20, 30 minutes on this, but it's just about bail. And many times nothing happens. I just like to have the client prepared for for what might happen. And because I don't like surprises, and the client certainly doesn't like surprises. You don't want the client looking back at you as they're being handcuffed and taken in the back. Why didn't you tell me this?
Good stuff, Robert. Thank you so much, brother. That's it for today's episode of Criminal Law Unfiltered. The first court appearance may seem routine, but it often shapes how a case unfolds from that point forward. To learn more about Robert Helfend and the work he does at the Helfend Law Group, visit robertmhelfend.com. Thanks for listening. Don't forget to subscribe, leave a review, and share this episode with someone who may need a clearer understanding on what to expect. And we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.